Welcome to the January 2021 edition of Outline, DLA Piper's monthly practical briefing on the latest planning law changes, and there are quite a few this month. My name is Trevor Ivory. I lead the DLA Piper planning team in the UK, and I'm joined by a couple of colleagues today who are much smarter dressed than me, for which I must apologise. I clearly missed the dress code memo, but I'm joined by my colleague and an associate in the team, Ross Corser, and also by my partner and one of our leading infrastructure planning lawyers in the UK, Howard Bassford. And between us, we're going to spend the next 45 minutes or so discussing what we think are the more interesting changes that have happened since our last session. After that, as before, there will be time for questions, so please do ask any questions you have as you go along using the Q&A function on the screen, and we'll come back to those at the end and get through as many as we can. So to begin, there have been quite a large number of legislative changes this time, so I just want to flag up the legislative Christmas presents that we've had from the government at the back end of last year. And sadly, I've got to start with Brexit. We still can't stop talking about it, can we? But I'm sure it won't have escaped anyone's attention that the government got a deal with the EU just in the nick of time at the back end of December. And in fact, the EU and the UK agreed 3 separate agreements during those last weeks before Christmas. And one of those was the Trade and Cooperation Agreement, which has some implications for the planning system. And that's the one I want to talk about today. So the European Union Future Relationship Act of 2020 is the legislation that incorporates those 3 agreements into UK law. And as I say, that includes incorporating the Trade and Cooperation Agreement. And I think the key points, not necessarily all of the points that I'm going to cover today, but I think the key ones in planning are very much focused on the agreements that have been reached between the EU and the UK in the area of environmental and climate change protection and provisions. Firstly, there is a commitment by both the UK and the EU to maintain the current levels of environmental and climate change protection, so that there is a restriction against either side looking to try and deregulate and reduce those protections. That provision in the legislation also confirms that failing to effectively enforce the current protections will be seen as a departure from existing levels of protection, or a regression, as the legislation refers to it. There's a separate obligation on both sides that is worded so as to say that each side has to strive to increase the level of protections. That to me, it feels quite aspirational. A commitment to strive to increase doesn't feel to me as if it has quite the same legal teeth as some of the other commitments that have been made. But nonetheless, there's clearly a declaration of intent on both sides that the current systems and the current protections that we have in place ought to be seen as a minimum and something to build from, rather than an end goal in themselves. There's also agreement by both sides to retain within environmental legislation some of the key European Union legal principles that have developed over the last few decades around environmental protection. Things like the precautionary principle, the polluter pays principle, the rectification at source principle. So a commitment significantly by the UK that those principles that are very much derived from European Union law will remain within our environmental protection legislation as we move forward. And the final point that I wanted to highlight is there is also a commitment to continue to require EIA and SEA of plans, programs and projects. So those systems remain with us. Whilst there may be changes to those systems that the government may want to make, then the principle of requiring environmental effects to be assessed is committed to in the Act. So I think all of this suggests that we're unlikely to see a fundamental shift in the approach to those parts of the planning system that have been very much driven by EU law in the last 40 years or so, and as I say, notably in the context of EIA and SEA. That doesn't necessarily mean that the systems remain unchanged, however, and whether the government looks to make changes to the system whilst protecting the underlying principles remains to be seen, and in fact is something I think that Ross is going to touch on a little bit later in the context of one of his cases. So moving on to the next slide, and moving away from Brexit, there have also been a number of statutory instruments. The government got busy before Christmas and left us with quite a lot of minor tweaks to existing legislation. I've set out the ones that I think are more significant and the ones that we need to be generally aware of on the screen. The first two sets of regulations that are on the screen now are very COVID specific, and effectively what they are doing is extending some of the temporary changes that were made to the system earlier on in the pandemic. They're extending the period during which those changes remain in place, predominantly relating to dropping the requirement for provision of hard copy documents and moving to a more electronic system, recognizing the lockdown and the difficulty of people being able to visit sites to inspect documents. The town and country planning regulations, the first ones on the screen, they were accompanied by changes to the PPG, and that sets out the various different dates that the different requirements have been extended to. So I'll refer you to those rather than send you all to sleep at 8:30 in the morning listing them all out, but they are all covered in the PPG. The second regulations, the Business and Planning Act regulations, they do the same thing, but in brief, what they do is extend the period during which the Mayor of London doesn't have to make available hard copies of the London Plan for inspection and can instead make it available online. That period originally was amended, or when it was introduced earlier last year, was ran to the end of 2020. That's now been moved forward to the end of 2021. So that requirement to provide an electronic copy rather than to have to make a hard copy available for inspection runs to the end of this year. There's a trend and a theme emerging. The next set of regulations, the environmental assessment of plans and programs regulations, they're in a similar vein, but they're relating to SEA, strategic environmental assessment. And in fact, the slight difference with these regulations is they are taking the temporary changes and the temporary move to electronic rather than hard copy requirements that were introduced last year, and they're actually making those permanent. So that will become the norm moving forward in terms of provision of documents under the SEA regulations. That move to electronic is not any longer linked to the duration of the pandemic. It's a permanent change. Likewise, in the case of the infrastructure planning regulations, they do very much the same thing in the context of DCOs and make the shift from hard copy documents to electronic permanent moving forwards. So a beginning of the end of the huge copying exercise that goes on with some of these large projects when trying to comply with consultation and publication requirements. Something different this time in the next set of regulations that are up on the screen, the changes to the permitted development rights, yet more changes to the permitted development rights coming in at the end of 2020. It feels to me as if 2020 may have been the record year for changes to the GPDO. This time the changes are quite specific. They relate to classes A and AA of Part 20 of the GPDO. And those are the classes that allow for upwards extension to create new dwellings. In the case of Class A, that's in the context of existing flats and increasing the level of the height of existing flats. AA deals with the ability to put residential on top of some existing commercial buildings. And what the regulations do is they are introducing a new prior approval requirement, so that any application for prior approval under either of the classes from the 30th of December last year now needs to be accompanied by a report that's been prepared by either a chartered engineer or another competent professional. And that report needs to confirm that the external construction of the building complies with the relevant part of the building regulations, the 2010 regulations. This is clearly a response to Grenfell and making sure that buildings that are becoming taller are safe and appropriate. As I say, those changes apply to any prior approval applications submitted from the 30th of December 2020, and the changes require a planning authority to refuse a prior approval application if that report doesn't accompany the report. It doesn't accompany the application, rather. It doesn't apply to any prior approval application that was submitted before the 30th of December last year. So there are some transitional provisions there if there are ongoing applications still being determined. That's what I was going to say on legislative changes. I'm conscious there's quite a lot there and I ran through it quite fast. So if you have any questions, do remember to put them in the Q&A function, and we'll pick them up later. Alternatively, if you need more detail on any of those regulations, please don't hesitate to get in touch after the seminar, and we can happily talk you through the information that you need to know. But we can now move on to our first case of the morning, and I think for lawyers, it's always exciting when the Supreme Court has something to say about your area of the law. And this one is particularly big, both because of the high-profile subject matter, but also I think because it's arguably the biggest judicial review that the planning world has ever seen, certainly in terms of the amount of court time that was taken up during its various stages. And I'm of course talking about the Heathrow decision, which was handed down just before Christmas last year. And we've got it's up on the screen. You can see the outline of the case. I think the key issue by the time we got to the Supreme Court was quite a narrow question on what constitutes government policy for the purposes of the Planning Act 2008. But it had started as a much wider case than that, I think, hadn't it, Howard? So where did it begin, and how did we get to that very specific issue in the Supreme Court?
Yes, well, the situation at Heathrow is an extremely long saga, which really goes all the way back to the beginning of its use as an airport not long after the Second World War. And the expansion of airport capacity in the southeast of England has been a vexed question for many years. And Heathrow is a gift that keeps on giving for planning lawyers. It gave the Heathrow Terminal 5 public inquiry, which was the longest ever public inquiry and sat for many years in a swimming pool in a hotel near Heathrow Airport. After the Heathrow Terminal 5 inquiry, the government felt the need to review the entire planning system for infrastructure projects in order to make them a lot more streamlined, a lot more straightforward to deliver. And the result was the Planning Act 2008. And that, as people will know, comprises a system of national policy statements and a development consent order program, so that the system is given certainty in terms of policy and in terms of delivery. In relation to Heathrow, the government had a number of goes, or successive governments had a number of goes, at trying to designate Heathrow or an airport in the southeast of England as the location for expansion. And by the time of the coalition government, it was really necessary to put in place a policy which would resolve this. And then going on to the first Conservative administration, the Cameron government, this was something which was felt needed to be addressed. And that resulted in the promotion of the Airports National Policy Statement following the Davis Commission on Airport Expansion in the southeast of England. So the Airports National Policy Statement was consulted on over a number of years. DLA Piper advised the government in relation to that process. And in the summer of 2018, the Airports National Policy Statement was placed before Parliament. It was debated in the late night debate, and then it was designated by the Secretary of State and became the policy. Now, the Planning Act 2008 has a specific regime for the preparation of national policy statements and for their challenge. And unsurprisingly, for something as controversial as the development of Heathrow, when there had been a number of options considered, including Gatwick, including the famous Boris Island, and of course, including other alternatives at Heathrow. With something as controversial as this, it wasn't long before a judicial review was launched. And as Trevor says, this was the largest ever planning judicial review in terms of the amount of documents, in terms of the duration of the case, and of course, the extent to which it's continued to be appealed. And the matter went before a fairly stellar judicial panel in the Divisional Court, where a large number of challenges were considered, and they related to things such as whether an alternative proposal at Heathrow ought to have been preferred, which would have been an extension of the northern runway, to whether habitats regulation assessment had been properly carried out, to the way in which consultation was conducted, noise impact, and climate change. And it's important to recognise that the airport's national policy statement was not proceeding in a vacuum. It was being developed at the same time as the UK government's position in relation to climate change, and in particular the Paris Agreement on climate change. And that was a key point which was raised by parties, including the various local authorities in the Heathrow area, who are frequently opposed to Heathrow developments. It was opposed by Plan B, Planet Earth, and by Friends of the Earth, as well as sundry lay objectors. The Divisional Court was very clear. It struck down every single challenge to the airport's national policy statement. However, a number of the claimants renewed their challenges before the Court of Appeal, and the Court of Appeal upheld every single ground except for certain grounds relating to climate change. And it found in particular that the government had not had proper consideration to its policy on climate change, and in particular the Paris Agreement. So this resulted in the airport's national policy statement being struck down on that basis, and it ceased to be government policy. At that point, the government decided that it wasn't going to appeal to the Supreme Court. However, Heathrow Airport Limited, who were joined in as an interested party in the process, decided that they would appeal, and it's open to interested parties in judicial reviews to take the fight on, even if the main defendant, the main respondent, decides not to, and that's what Heathrow Airport Limited did here. And they took it to the Supreme Court, and the Supreme Court found in favour of Heathrow Airport Limited, with the result that the airport's national policy statement has now been reinstated, and it is now the UK government's policy in relation to airport expansion in the southeast of England. So that is the history. It's a long, complicated, very interesting, very Wikipedia sort of history that's could occupy a morning of interesting reading. But the points before the Supreme Court, because of the narrowing of the grounds, had reduced to these questions of climate change, and ultimately turned very much on the question of what is the government's policy. Now, here, the criticism had been in the Court of Appeal that the government had been saying one thing in relation to climate change, and it had entered into a treaty, the Paris Agreement, and these hadn't properly been considered. Now, the Supreme Court looked at that, and it looked at what was going on. It looked at the statements that were being referred to by the claimants, and whether they really did amount to policy, whether the government did have regards to them, whether the government complied with its statutory obligations under the Planning Act 2008. They're quite restrictive. The Planning Act 2008 is highly legislative. There's a thickness to the legislation, meaning you know pretty much what has to take place, and then the documentation and the way that the policy was expressed. In relation to this question of policy, and this is perhaps the most interesting point, the court found that the term government policy, and the Planning Act says that the government has to have regards to government policy. In terms of government policy, it has to be construed narrowly. It doesn't mean any statement offhand in a press conference or by a minister at a dinner or something said in Parliament. What it means is something that's been properly worked up, documented, consulted upon, and which is clearly described as government policy. So it's not necessarily that every written ministerial statement or statement to the House is going to have that status. And it found that the various utterances by ministers like Andrea Leadsom, which was highly qualified, were not such policy. It meant that that civil servants should not be faced with what the Supreme Court calls a bear trap, where they have to rifle through Hansard and any press clippings to work out if ministers have said something unhelpful before they make decisions. And that's really useful clarification. I think it's interesting as well, because that's a matter which, whilst the Planning Act has its own specific legislative regime, that's something which could sound in other legislative regimes when we think about government policy.
I think that's certainly one of the interesting aspects for me, Howard, because I think the takeaway, I think, is fairly clear in the context of DCOs and the 2008 Act and the NSIP regime. I think government policy is defined in the legislation, and what this case seems to have done, I think, is put flesh on the bones of that definition and sort of tell us what it means. But there are some interesting takeaways, aren't there, for the 1990 Act? And you mentioned the written ministerial statement point. I mean, where do you see the sort of the crossover into 1990 Act? How will this impact those bringing forward more traditional planning applications?
I think that there is a potential for a crossover, but we don't quite know where this will lie. And I suspect this is something which is going to provide fruitful grounds for litigation in time to come. So we are, as it were, at the high watermark of the restriction on the interpretation of government policy. It's its most restrictive interpretation just now. In the 1990 Act regime, there is no equivalent requirement to refer expressly to government policy. The governing decision-making provision is, of course, Section 38(6), which says that where regard is to be had to the development plan, decisions have to be made in accordance with it unless material considerations determine otherwise. I paraphrase. That last term, the reference to material considerations, is where such government policy would come in. Now, in those circumstances, it's often the case in public inquiries and hearings, local plan inquiries, enforcement, that government statements will be prayed in aid of particular positions, and weight might well be urged to be given to them by advocates in inquiries who are trying to influence the minds of inspectors. Now, I think what we've got here is a question of whether it really will be policy or not. And I think that's something which could very well be debated. The Supreme Court will have wanted the implications of its judgment to be restricted. They don't want to open a great floodgate for litigation in relation to planning matters, but they will have been mindful that this is something which could affect the type of thing an advocate might say, well, this is the government policy because it was mentioned in the House of Commons and the minister said this. In those circumstances, there's going to be a question about whether that or a written ministerial statement is in fact policy in the same way that a fully worked up, consulted upon, considered and drafted policy is without qualification, issued by civil servants with ministerial imprimatur. So that's something that's going to be important. I think the way you get to policy is also... Go on, Trevor.
Sorry, Howard. I was going to say, I think I agree with you there, and I think it's the Supreme Court justices yet again, and I can't think of a recent planning case that's been before the Supreme Court where they haven't been saying there is decision maker discretion in planning, and ultimately a lot of this comes down to weight, and the court doesn't want to be getting involved in second guessing those judgments from individual decision makers on what weight to attach. And I think here you have the MPBF in a 1990 Act context that is clearly government policy. you then sort of have a range through written ministerial statements and down to sort of press releases and off-the-cuff comments. And it feels to me as if, whilst ultimately it is a question of weight that an individual decision maker is going to have to decide, what this case is saying is it may not be unreasonable, it may be perfectly justifiable, in fact, to place greater weight on something that is government policy in that very clear form versus something that may still be an utterance from government in one form or another, but it doesn't have that same government policy tag to it. That feels like the sort of the distinction that perhaps is being drawn.
I think that that's very much where the discussion will end up. I think that that is how this should be treated in public inquiries, and it's going to be for advocates, consultants, negotiators to use that question of weight sensibly to come to the positions that they're taking. There's an important point though about weight in this, and like many judicial reviews, this does emphasize the way that decision makers carry out their duties, because the question of whether the Paris Agreement had been taken into account sounds in this judgment in a number of ways. And the Court of Appeal's judgment felt quite critical of the way the Secretary of State had dealt with that. And it seemed as though there was an allegation of misdirection by the Secretary of State to himself. In those circumstances, the Supreme Court said, well, no, the Secretary of State did consider all of this, did consider the Paris Agreement. It was before him. It was raised in consultation as a point which had been considered by consultees. And the Secretary of State had regard to it and then concluded the weight that he was going to apply. So that element of decision making and the way weight is attributed is reinforced by the Supreme Court judgment here. And it also says that one mustn't be too legalistic about the way you apply things such as the content of environmental reports for SEA, the question of whether particular policies have been referenced or not. If they're then raised in responses to as a criticism of a report, then that's a means that they can be in the mind of and before the decision maker. They don't have to be retroactively inserted into the report. So some useful reminders there about the way that decisions should be taken.
Thanks, Howard. An interesting one with wider consequences than just the case itself, as is so often the case with Supreme Court decisions, of course. So we're going to be staying with the subject of climate change. Ross, I think you've got a decision not quite so so illustrious as a Supreme Court, a High Court decision, haven't you? That I think probably comes as a relief for most of us. But talk us through it.
Thanks, Trevor. Yes, the case that I'm going to be talking about this morning is an EIA case. So my apologies in advance. I'll try not to send you back to sleep this morning. The case concerns whether environmental impact assessments for development should also consider the impact caused by greenhouse gases, which arise from the use of end products associated with the facilities that are under development, as opposed to the impact caused by just the development itself. In the case, Finch sought judicial review of the local planning authority's decision to grant planning permission to expand an existing oil well site and to drill 4 new oil wells for the production of hydrocarbons over a 25-year period. The developer carried out an environmental impact assessment and the local planning authority was provided with an environmental statement assessing the greenhouse gases that would be produced from the operation of development itself, which is all very standard. It didn't include an assessment of the greenhouse gases that would be emitted when the crude oil produced from the site was used by consumers. So, for example, fuel in motor vehicles. Regulation 4.2 of the EIA 2017 regulations actually requires an EIA to identify, describe, assess in an appropriate manner and in light of each individual case, the direct and the indirect significant effects of the proposed development. So the question then the court really had to grapple with was whether a developer's obligation under Regulation 4, and specifically the use of the words direct and indirect significant effects, extended the scope of EIA to the end products themselves and the emissions that they themselves generated. In the case, the court said no, this was the High Court. Indirect significant effects were to be decided on a case-by-case basis, but nonetheless couldn't extend to matters which were outside the scope of the development being assessed. I think that would have created a very substantial burden on developers, just because the environmental effects of consuming an end product would flow inevitably from the use of the raw material. That in itself couldn't provide a legal test for deciding whether they could be treated as the effects of the proposed development. And the judge gave quite a useful example in the case. He said that when the oil left the site, it became an indistinguishable feature of the international oil market. So for example, use in planes, construction materials, cars. How can it possibly be the case that a developer would be required to assess the impacts of greenhouse gas emissions generated through these end users? I think it would produce quite a chaotic result, really, that wouldn't just stymie industrial development generally, but it would lead to far wider economic consequences generally.
I think that's right, Ross. And as I said, introducing it, I think this case kind of comes as a relief, because I think the consequences of the claimant's arguments in this case, if they'd have succeeded, then they could have been quite wide, couldn't they? I mean, that it's not just industrial development that would have been affected by the sort of approach that the claimant was advocating.
I think that's right. I think if the claim had been successful, the scope of EIA could theoretically have been extended much wider to things like assessing waste generated by occupiers of residential developments during the life of the units, or business and retail occupiers, or greenhouse gas emissions of staff travelling to and from places of work. I think it could have been significantly wider and would have caused quite chaotic results generally. So I think it would have been the tip of the iceberg, and as I say, it would have widened immensely the scope of what we consider to be the scope of EIA now.
So where does it leave us, Ross, in terms of what the regulations still require indirect effects to be considered? It's clearly the case is telling us that we need to, on a case-by-case basis, to decide what the relevant indirect effects are. But what sort of things do you see post the case continuing to be indirect effects that need to be assessed?
So I think indirect effects really cover those consequences which are less immediate, but nevertheless effects which the development itself has on the environment. The court did go on to say indirect effects are essentially a matter of planning judgment to be determined on a case-by-case basis. Howard, do jump in if you have any other examples, but my thoughts on this were things like delivering materials to site, or disposing of non-recyclable construction waste from the development, things which are ordinarily assessed through EIA at the moment.
I think you're right, Ross, and I think that the question of remoteness is really important here, and that's something which lawyers are very familiar with, because it's a concept we apply in areas like negligence. But a classic example of an indirect effect would be something such as marine development, where you put a new development in an estuary on an area of land that's not subject to any particular designation. And as a result of it being put into the water, there's a geomorphological, hydrological consequence, and that then affects a protection area which is protected for birds some way distant. And so there's that causal link that's the indirect effects. So that would be a very good example of the sort of instance that we would have. Or for instance, the impacts of emissions on a receptor that is remote from a scheme may be an indirect effect. Those are the sort of things that would happen here. In all of these things, it's like ripples on a pond. Close to the development, there isn't very much of an impact. Close to development is where the impacts are felt most keenly and where they're direct within the red line. As you move further away, the ripples diminish and ultimately become indistinguishable from what's happening in the background environment. And what the court, I think, said in your case was that the minute the oil passed through the gates of the drilling site, it was in the international market, and so the ripples stopped at that point, and the indirect effects are not attributable to the development.
I think that's right. I think it would be very, very difficult to try and create that causal link between oil which was generated for use in planes in one part of the country to then link it somehow to development and at the other end of the country, even though that's where the oil came from. I think, as I say, it has much wider consequences than just this type of minerals-based development. I think to conclude then, even though the claim was itself unsuccessful, which I think was clearly the right outcome, the case itself is still very important for a number of reasons. Firstly, the court gave a very robust judgment against widening the scope of EIA, which again would have resulted in disastrous ramifications for development, resulting in end products for consumption downstream. And I think this is generally quite a strong signal to other climate action groups in these type of claims. And most planning practitioners will tell you that most judicial reviews in this field actually occupy the vast majority of climate action judicial reviews. I think secondly, the case comes at a very useful point in time for EIA generally, which is immediately after the UK-EU cooperation agreement that Trevor referenced before. The government has already indicated recently in the National Infrastructure Strategy that it intends to reform EIA. So I would expect some further activity in this space in certainly the coming months.
Thanks, Ross. I'm conscious of time, so I'm going to move us on to our last case of the day, which fortunately I think is a fairly short one, although I think it's an important one just to flag up. This is the Gluck case, which was in the Court of Appeal, and they handed down judgment just before Christmas. And the case itself and the decision in the case is relatively specific. It related to the GPDO, specifically to Article 7C, and the question was over whether there is an ability to extend the period for determination of a prior approval application under the GPDO. And the reference in 7C, the wording of 7C, is wording that is familiar across the planning system in terms of allowing a determination period to be extended by agreement between the applicant and the authority in writing. So as I say, the point of the case was whether you could extend the determination period for prior approval. The court's answer to that was yes, and none of that seems particularly interesting. But in the context of deciding on the particular facts, whether an extension had been agreed by the parties to the particular application, there was quite a lot of discussion by the three judges, and in fact, in the end, the judges disagreed, which is increasingly rare in the Court of Appeal. But there was a dissenting judgment given as to what the requirement for in writing meant, and I think that the point for me, there are 2 points that come out of it. Firstly, the judges were in agreement that if any extension of time has to be finite, you can't simply agree that you'll extend until such time as one or other of you is bored of the process, or extend, until you agree otherwise. There needs to be a specific date that both parties, the planning authority and the applicant, are agreeing that the time limit is extended to, which is common sense, and the judges were in agreement on that. But where the disagreement really kicked in was in the question of what does in writing require. Now, one of the judges was of the view that requires both parties, both the applicant and the planning authority, to have confirmed in writing to each other, and that could be an email, that they are both agreeing to the extension of time. The other two judges took a slightly different approach. Their view was that it didn't need both parties to set it out in writing. Actually, it only needed the agreement to have been recorded in writing by one of the parties and shared with the other. And that's what had happened in the case, was that a conversation had happened between the applicant and the planning authority. They'd agreed an extension of time. The applicant's agent had then emailed the planning officer and said, just to confirm, I understand that this has been the determination period's been extended to X date. And for two of the judges, that was enough. There'd been an agreement, an oral agreement, which had been recorded by one of the parties in writing, and it hadn't been challenged by the other party. They felt that that would have been enough to constitute or to discharge the requirement of the legislation. The other judge disagreed. And the other judge's view, as I say, was very much that no, you both need to have set it out in writing. And his point was there is no and between the requirement, between the words the applicant and the authority and the words in writing. So he was saying it's not that there needs to be an agreement between the applicant and the authority, and that agreement needs to be recorded in writing. His view was the words mean that both the applicant and the authority need to have agreed to the extension in writing. Now, in the end, as I say, it actually didn't make any difference, because in this case, the planning authority had replied. Now, the officer hadn't expressly agreed to the extension, but had gone on to talk about what the next steps were. And so all of the judges were satisfied that actually both sides had agreed in writing, regardless of that legal distinction that they were drawing in that particular case. But I think it is an important point, and it's one that we see all the time in planning. It is very rare that planning applications that we are dealing with are determined within the statutory period. That there is always a need to extend that statutory determination period. If you don't determine it, don't extend it rather, the consequences for the applicant are that the time limit for a non-determination appeal is running. And ultimately, if you miss your window, then you lose your right to a non-determination appeal, and that can trap you if ultimately the application starts to hit a rut. You can get trapped with no appeal mechanism to get you out, and need potentially, in the worst case, to have to resubmit an application, start again in order to get through to an appeal. So I think it's a timely reminder that if you are extending periods for determination in any context of the planning application, because they all use similar wording, you need to make sure that firstly, that you are remembering to extend those determination periods, but secondly, that you are making sure that agreement is recorded in writing. Best practice, because there's clearly some debate amongst the judiciary at this stage as to what the right answer is, best practice is that both sides should each email and confirm their agreement to the extension of time. But if, as an applicant, and you do see it on occasion where the applicant has emailed but is struggling, planning officer may be busy or maybe off or whatever, is struggling to get a response from the planning officer, the fallback would be to at least have sent an email yourself recording the fact that you have spoken and that you have agreed to an extension of time. But in an ideal world, definitely the takeaway is to remember to try and make sure that both parties are agreeing to that extension of time in order to avoid an argument. The fact that the three senior judges in the Court of Appeal didn't agree on the issue suggests that it's only a matter of time before we end up seeing a case that tackles the issue directly, and let's try and make sure it's not yours would be my advice. Which, bang on the 45-minute mark, I think brings us to the end of the presentation. So we're on time. Well done, Howard and Ross. We've kept time, which is always rare for lawyers. So that gives us about 15 minutes now for questions. If you have any questions, do put them in the Q&A box. Howard, we've had one come through, which is a question about what is the implication of the Supreme Court case for the national policy statement. Is it automatically does it automatically come back as a national policy statement, or is there anything that the government now needs to do to bring it back into force?
So as matters stand, the Airport's National Policy Statement is the government's policy. It has resumed its effect, and it is the document against which an application for development consent in relation to Heathrow Airport would be considered, and it would also be considered as an important and relevant consideration in many other planning applications relating to airport provision in the southeast and or development in the Heathrow area. So it is the policy as matters stand. At the same time, however, we exist in the real world where passenger numbers, flight movements are much reduced, and there are calls for its review by various parties, including in relation to changes to government policy on climate change. So no doubt the government will be considering those requests as time goes by.
Thank you. We've got a few questions come through actually on the Gluck case and extensions of time. The first question is whether an email from an applicant to a planning authority proposing an extension of time would count. Welcome views, Ross and Howard, from you, but I think for me, no, I don't think it would, because that isn't evidence that an agreement has been reached. I think in the case there had clearly been a conversation and an agreement had been reached verbally, and then the follow-up email had sort of simply confirmed that agreement had been reached. I think an email that says, shall we extend time or can we extend time, I don't think it gives evidence that there is an agreement there at all. The planning authority at that point hasn't expressed a view one way or the other. So I think a court, to my mind, would say no, that isn't evidence of any agreement. It would need to be more than that.
I think you have to be really careful about how you deal with this. The important thing in any agreement, and this is day 2 of law school, is that there has to be a meeting of minds between the two parties. So it has to be possible to determine that both the planning authority and the applicant meant the extension to happen. So you've got to have got that far. What that means is that if you were a particularly aggressive applicant and at midnight on the day on which the relevant period would expire, you fire off an email to the local planning authority saying it's midnight. If I don't hear from you by 11:59, then I shall assume that the time is extended. And those circumstances, that's not likely to be found to be an agreement, because it's effectively just a proposal with a threat. And so you have to get to a position where you can say, well, there was a conversation, we did agree it, this email records what we agreed verbally, and therefore it's evidence of a conversation that took place in our meeting of minds, our agreement. And that's what the court will be looking for in determining any of these.
Yeah, I agree with that. The other question on a similar vein is the extent to which that case can be applied outside of the GDPO in the context of planning applications, the EIA regime and elsewhere. And I think for me, the answer is I think there is a general application beyond the GPDO. It applies to my mind, or it doesn't apply directly, but it's certainly helpful in terms of interpreting similar wording elsewhere, and you see almost identical wording, I think, under the 1990 Act and in the DMPO around extensions of time for the statutory period for planning applications and such like. So, to my mind, you need to take a similar approach wherever the wording is that it's agreement, local authority and an applicant agree in writing. It's when those words are used in whatever context of the planning system, I think. Just looking at other questions, Ross, there's one that's come through on the question of indirect effects, and the question is, does the case offer any guidance on how to sort of understand where to draw the line, or is that left very much to sort of planning judgment in an individual case as to the point at which something is sufficiently remote that it's not necessary to include it in the ES?
The case essentially left it to planning judgment, as is often the case when the court is signalling that it doesn't want to be seen to really interfere on those kind of decisions. I think that the key point for indirect effects is that it covers the consequences which are really less immediate, but which nevertheless have effects on the development itself, and which effects which have which result from the development on the environment. So I think the answer is no. It doesn't give specific guidance on it, but you have to really apply a level of common sense when looking through the effects that you have to establish whether or not those would be of an indirect nature.
It's back to that, as ever, the conversation that Howard, you and I just had, isn't it? Which is all about planning judgment. Everything's about planning judgment at the end of the day.
And we mustn't forget that there's always the option of scoping, and that's really helpful in terms of getting to a position where the decision maker and the applicant can agree the types of consideration which are reasonable to have in mind. It doesn't stop an objector raising a point which hasn't been considered previously, but it does at least give strong guidance and a lot of protection about the matters which should be borne in mind.
Yeah, and then we've also had a question back to the very beginning of the session. Question around the Future Relationship Act and the consequences. And the question is, what are the consequences of a breach of the commitments? So presumably the question is thinking of, what if the government were to try and move away from the EIA regime or whatever? It's an interesting question, and the answer is it will depend at the way that the Trade and Cooperation Agreement works. These are commitments that both sides have made, and the overarching agreement is that we have the now relatively free trading arrangement that has been put in place under the agreement. It's not free trade in the way that we've been used to, but certainly trade is easier in a number of sectors than it would otherwise be had we have gone to World Trade Organization rules, and certainly we don't have tariffs. And what the agreement does is if there are regressions from the commitments that have been made in those agreements, then the consequence is that the other side, so if it were the UK that were being naughty, that would entitle the EU to take retaliatory measures, whether that be imposing tariffs or taking other steps to restrict trade in order to sort of penalise the offending party. So there's no clear in the legislation. There's no specific remedies, but it very much comes down to triggering what the other side would like to do by way of sort of retribution, if you like.
I think some interesting questions will come out of that, Trevor, in relation to first of all, what if the UK courts determine something differently to courts on the continental mainland, and it's a decision of the court which is felt not to be upholding or to be diverging from the position on the EIA, SEA on the continental mainland. That's the first one. The second one is, what if the domestic authorities in the European Union are failing to enforce environmental impact regimes as fulsomely as we tend to here in the UK, because by and large the UK is a good performer in those fields. If the domestic authorities are in EU member states are not enforcing matters, does that affect the position? And I think these are points which will be in the law of unintended consequences, and we'll need to look at those as matters of law.
I think that's right, and a lot of it will depend on the state of political relations as to whether either side is looking to take other steps and is looking for a reason to do so. It feels as if there'll be a lot of diplomacy and political factors that lead into questions of whether anybody actually resorts to the agreement or not.
Yeah.
Another question, we've probably got time for just about one more. Another question's come up, Ross, again in the case of the Finch, or in respect to the Finch case. And the question is around if there's a development proposal, if it feels very specific, it feels as if someone has an issue sitting on their desk as we speak, but a proposal for substantial afforestation under PD rights, would that, for the purposes of EIA, would you need to take into account the impact on neighbouring listing buildings in terms of the impact on curtilage or presumably setting as an indirect effect? Interesting to me in terms of the premise of the question, because I'm not entirely sure you'd need a PD right for forestry, agriculture and forestry not being a use, not constituting development, rather, for the purposes of the 1990 Act. So I'm struggling personally to envisage circumstances in which you'd need that. But I think that there's a question there, isn't there, Ross, in terms of if you are doing something, if your development proposal, whatever it is, has a likely significant impact on the setting or curtilage of a listed building, is that an indirect effect that potentially needs to be caught? I think it probably is, isn't it, Ross?
I would think so, but I would again defer to the point that Howard raised on scoping. I think it'd be because of the fact that it has to be determined on a case-by-case basis. I think it's probably something that you would, in this case, really look at the scoping regime for and perhaps approach it on that basis. Howard, do you agree?
Well, I think it's important to establish the extent to which the EIA regime is going to apply to this, because of course, if you are in a situation where environmental impact assessment is required, then under the permitted development right, if environmental impacts are triggered, then EIA does take effect. I think that's a question of looking at Schedules 1 and 2 of the environmental impact assessment regulations, establishing if we're going to fall within those. Then you are looking at whether there is going to be an environmental impact that is going to require assessment. If that's the case, then you do lose your permitted development rights. Impact on the curtilage of listed buildings, because cultural heritage and material assets are a receptor for environmental impact assessment purposes, does mean that you have to consider this. It's the sort of thing you'd need to look at the exact circumstances of the case, that you'd be able to discuss this, come up with a case for the position or not. You decide, if you are predisposed to carry out assessment, whether you're going to screen or whether you're going to attempt to rely on the permitted development rights on the basis you do not actually permit an impact on the relevant listed building receptor. So I think you have to look at the circumstances. I would say that, wouldn't I? But you're effectively establishing if there is likely to be a significant effect, and whether you're in the regime.
And I think the other thing in the context of impacts on curtilage or setting of listed buildings is regardless of the EIA regime, you're also, of course, subject to the very specific protections that are afforded by the Listed Building Act. So that would always, whether it's EIA or not, you still have that requirement to bear in mind, I think, in those contexts. That takes us just beyond the hour mark. So apologies if we didn't get to your question, but we will finish promptly as always. Thank you all very much for attending. Our next session will be next month, and we'll be circulating details of the date and registering for that shortly. We'll also be making a recording of this session available online in the next few days. If it was so good you want to listen to it again or watch it again, then you probably need to get out, more lockdown notwithstanding, but the option is there for you. But Ross, Howard, thank you very much, and thank you again to everyone for attending, and see you all soon. Take care.